to get our systems around the state to actually implement the criminal justice e-filing project. With that, the board is set up on page 5. We get all the way down to part 2 on page 6 of the bill. And page 6, part 2, section 2-1 is setting up a uniform misdemeanor citation form. And this, as I guess is obvious, is a way to make sure that jurisdictions around our state actually have a uniform misdemeanor citation form that's used in every single state. And we allow the judicial, every single district, we allow the Judicial Council of Georgia to set the rules up for that, to create that consistency around the state there at the end of that section. Moving on to section 2-2, also on page 6, we are confirming as we get into section 2-3 as well, that there are certain offenses that can be prosecuted by way of citation. And this is a may, as you see at the top of page 7. And we list out 4 different offenses there that can be prosecuted by way of citation. This is already being done by our magistrate courts around the state right now. And to be clear, we're not waiving the requirement to have someone arrested, as we see at the bottom there, actually on line number 218. If an offense requires a fingerprint, then we confirm that this subsection does not waive that requirement for custodial arrest for the purpose of fingerprinting. You just won't have to go through the bail process at that point after you're fingerprinted.
What are the 4 on, I guess they're set out on line 202. What are the 4, just so we have a...
I know 16, 13, 30 is misdemeanor marijuana. One is
misdemeanor drug possession, misdemeanor shoplifting, misdemeanor refund fraud, and misdemeanor criminal trespass.
Did you hear all that? No. Misdemeanor shoplifting, misdemeanor refund fraud, misdemeanor criminal trespass, and misdemeanor possession of drugs.
And that's defined as a weight of being under
1 ounce of marijuana.
less than 1 ounce.
And that's all listed on line 202. Those offenses are spelled out. And then at the bottom lines, starting on line 226, we also confirm that if someone fails to appear, there will be a warrant obviously issued for their arrest. And at that point, they will have to make bond, reasonable bond, once they are brought back in at that point. Moving on to page 8, section 2-4, this is when we get into some bail reform. And as we see there, starting on line 243, when a court is determining bail for someone with a misdemeanor, we're confirming the fact that the court will not impose excessive bail and shall only impose the conditions reasonably necessary to ensure that person actually shows up to court and to deal with the safety of citizens. What we're doing there is confirming what the purpose of bail actually is. A one-size-fits-all model doesn't always work, and it's looking case by case at the person that is up for bail. Looking on line 257, moving down there, we also have what the court shall consider when determining bail for someone. And we list out A through E there, the factors that a court would look at, again, looking at the purpose of bail, making sure someone actually is going to show up for court, looking at public safety, but looking at the individual, what is, $1 amount for one person, maybe something completely different for someone else, and making sure that person actually can make that reasonable bail.
I mean, as a practical matter, and members, if you have a question going along, just hit the button so I can see, and I'll be happy to call on you. I think this is the kind of bill that just begs for maybe just doing it section by section as opposed to going back. I mean, I remember when the bill came out, I know there was some talk about bail and so forth, but at the end of the day, and there was some heightened volume in some areas of the state by some certain individuals. But on line 257, I see, and what am I missing here? Shall consider. I mean, court retains discretion. There's no mandates here. Is that a correct statement? Or
That's correct, and it says there shall consider, and the bill always said that as far as I know. And so the idea that we're doing anything drastic here, I mean, I can't imagine any controversy in having a court consider someone's earnings, income, their financial resources, their ability to actually, pay the bail. Again, a one-size-fits-all model does not work, and so giving discretion to our judges to look at case by case, I think, is what we want.
But right now, they're mandated to go ahead and set bail on a misdemeanor regardless, X amount. Is that a correct statement?
That's my understanding.
Okay. And so this just gives them the discretion to take a look at the ability.
That's correct.
Ms. Silcox.
Thank you, Mr. Chairman. My question is with the catch-all here. Any other factor the court deems appropriate at line 263, that just seems really wide open.
Yeah, well, I think, again, you want to give that discretion to a judge. I think the judge has A through D there, obviously, what they shall consider, but they also shall consider what they deem appropriate. You give that extra flexibility to looking at case by case when determining bail. And so it's not a drastic policy change either to give them, I guess, if you're giving them discretion, you're having them look at someone's earning potential and the purpose of the bail, then to have that catch-all, as you said it, to give them the flexibility to look at anything else and maybe a factor they should consider, I think is a good thing.
Just following up on that, just so we can look at it from a practical standpoint. I mean, right now, and if you wanted to call on someone to assist you with the question, that's perfectly fine. I mean, right now, we talked about just in the 4 on the citation piece, the shoplifting, refund fraud, et cetera. Let's just take the shoplifting. I mean, right now, misdemeanor shoplifting, the process on the setting of bail, what are the restrictions right now that are on the court that this bill would go ahead and address?
Yeah, there is a bail schedule set up for that right now. Do you know the amount?
I mean, what are we talking about? Numbers.
It'll depend by jurisdiction, but each circuit will have a schedule set.
Mm-hmm.
The judge can depart from a schedule, but the fact of the matter is when they have the schedule, they're moving through based on the schedule itself and not necessarily making individualized determinations on each case. And of course, as we all know, a $500 bail for one defendant is not necessarily the same as a $500 bail for another defendant with significantly different financial resources available. So that's kind of the point to get at, is to raise the issue with the judge to say, consider these factors in setting bail.
Ms. Silcox. Let me come down. I'm sorry. I thought I saw a light and then it went away. You got to push the button. There you go.
It's not letting me. I just want to return back to the catch-all and the E. Can you give me some examples of what other factors the court might actually look at?
I don't know, but you may hear an individual story about someone that maybe they work 2 or 3 jobs, they're caring for a family member at home. I think you have the flexibility to hear a story and to match bail for that person. I'm sure there's some prosecutors and judges in the room that can give us some individual examples that can be looked at, but that gives that judge flexibility. So again, one size fits all just does not work, especially in our criminal justice system.
Ms. Dickerson. Mr. Bodie.
Welcome back, old friend.
Happy to be back.
Good to see you back in the room. Line 257, it seems like to me, and from my practice of criminal law, you're giving a extra layer to the 4 factors that we have always had above between lines 250 through 255. So basically, lines 257, which is section 2, a defense lawyer can come and argue the 4 factors of why a client should be granted bail, but then they can also argue those 5 additional factors if it's a misdemeanor.
That's right, but you keep in mind that 248 is what the court through 256 the court shall do.
Shall do.
And
Exactly.
so I do agree that you could argue these other factors to the court to consider, but the first part is what the court shall do. This is the permissive part of it.
Okay.
But that's correct otherwise.
Okay. Thank you.
Ms. Price.
Welcome back.
Thank you, Mr. Chairman. Again, focusing on lines 257, I'm just concerned about potential for time constraints to not allow A through D to happen, given that it says shall.
Well, that's what the court, when they're turning bail, they shall consider. But what is the current time period they must have the hearing on?
There's no, yeah,
48 hours? Or-
it's just a process, but it's not a statutory, so.
Right. Mhm.
The purpose of the, so part of the purpose of this section.
Mr. Miller, do you want to come up? You may want to just,
Might as well.
thank you.
Thank you, Mr. Chairman. Representative Price, I think it would be important to point out, but so part of the consideration when we discussed this in the Reform Council was the as soon as possible language, and requiring it to be done within a certain time period. You know, what we're recognizing here with as soon as possible, which our wonderful legislative counsel actually pointed out to me is a defined term in Georgia Code, which essentially says related to all the exigencies required around a case, is to set a time period that will work in our various jurisdictions that have varying financial resources, but also to note the importance of having this within a reasonable time period in order to consider these factors when determining bail. So to be clear, there's nothing here that requires a schedule to be repealed. A bail schedule will still be there. But in the instance where you have, for instance, an individual that's set on a bail from the schedule, remains in the jail because they're unable to afford that bail, to allow the judge to come back and as soon as possible consider the financial resources and whether that is the barrier for the person who would otherwise be eligible for bail and otherwise not considered to be a serious risk to be able to be released.
Thank you.
Good job.
Ms. Silcox.
Thank you, Mr. Chairman. I guess I'm concerned, I understand the point of this, and I'm all for criminal justice reform. But I guess I'm concerned that in the interest of injustice for all, I'm concerned that, you know, if you throw this wide open like this, with this catch-all, that at some point there may be some unintended consequences. It may be very difficult for some of these cases to go to the appellate level because they're so disparate, they're so individual, and there's no standard here that clearly that you know, you can argue, oh, it was done on a case-by-case basis, and I'm just concerned that, like I said, the long-term consequences of this is there may be no standard at all.
I understand your point. I think the purpose here would be to say that, you know, first of all, we're operating in the section that is only applicable to bailable offenses. So we're not talking about bail-restricted offenses. And then also to say that, you know, right now, under current law, a judge, if they take the time to consider the person that's been sitting in jail, can be operating on a number of different factors. What we're pointing out here is ones that we specifically want the judge to consider, but also to say, you know, leaving the any other factor in, because we don't want to unintentionally exclude things that are relevant to the purpose of bail, such as whether the defendant has prior failure to appears, whether the defendant has a serious risk of recidivism, things of that nature that are within the judge's discretion now, too.
I think it's also important to keep in mind the lines 250 through 255, 256 of current law, that, you know, someone's not going to be released on bail unless the court finds that person poses no significant risk of fleeing, no threat or danger to any person. You have the safeguard already there, so you're not going to have someone get around those requirements in this new provision, these new provisions that we have.
So you think there maybe should be an and with those first ones and the second section?
Well, I think with respect to the second, what is there under current law and the silence under current law that you see in R 257 through 263 as proposed, implies that a judge can consider these things now. I think to a certain extent, this bill helps to inoculate our localities from future suit on the basis of not considering the financial circumstances and due process rights that may be involved in that situation as well. By the same token, I think by inoculating it also requires our locations to actively consider these things.
And if you need to follow up at a different time, that's fine. What is the status of the Calhoun case?
My understanding is the 11th Circuit sent it back to the district court judge for a more finite determination. Marissa, you'd probably know better than I. Is that still pending? Yeah. So it's back in the Northern District, but still pending there.
And
So
the district court's original finding, in a nutshell, was what, as it related to the city of Calhoun's practice?
That you have to some extent, consider financial ability to pay as it relates to constitutional rights. But I think the 11th Circuit, and I don't want to mislead anybody.
No.
I think the 11th Circuit's opinion was with respect to whether the initial determination by the district court judge was finite enough to give anybody anything to go off of moving forward, which is why it got sent back.
And without editorializing, I mean, did the district court, when Judge Murphy made his, and I don't remember, I read the decision, it was a while ago, though.
Right.
It was more than a year, I think. What was the basis of his initial finding, if you can recall? If you don't, it's fine. We can always double back on it.
I will probably defer. I know, Marissa, you may.
That's all right. We don't have to, I don't want to labor that right now.
Yeah.
I'm trying to, what we're trying to do is piece together what findings there have been. I know there were some strong feelings in that case.
I want to say it was a substantive due process issue, but I'm not certain on that.
I'm just wondering aloud what the basis of the decision was, and was it just, was there precedent that was being relied upon at that point, or not? And if we can find that out, but I think just it's really more for more of a global understanding on the issue for the committee.
Sure.
We'll see if we can get on that. Mr. Bodie.
I don't know if the representative earlier was kind of hinting at this as far as time limits are concerned. Could we, or has a thought ever came up or ideal of codifying the Riverwood case to actually put that into statute where if an individual has been arrested, it's been 48 hours, that the person has to go before a magistrate, or if it's been 72 hours without a warrant, that they have to go before a magistrate. Has it ever been any conversation, since we opening up the bail bond code at this portion, is that something that has even been considered?
So with respect to any finite time determination, the council considered and discussed at length. And I think a lot of members of the council were eager to find some route to go with that. But the problem is the disparate resources available in our various jurisdictions, and making sure that we weren't creating unintentional consequences by having a finite time that may work in DeKalb County, but may not work in Bibb County or in Decatur County, if that makes sense.
Yeah, I'll reserve. I'll reserve.
All right, thank you. That was helpful. Senator, if you want to continue.
Okay. On page 9, line 277, we get to the next substantive thing we're doing, and this is still under the bail section. For the offense involving the act of family violence, this confirms that those offenses will not be subject to a schedule of bails. They'll be done on an individual basis. I think that anybody that's ever dealt with the area of family violence knows how those cases are definitely case by case, and that makes sure that we're not subject to some sort of schedule of bails with those offenses. Getting out of that section, the section 2-5 on page 10, we are confirming the ability to release someone for bail or on their own recognizance for the purpose of entering a pretrial program. And we're also confirming that any judge can actually, not just an elected judge, any judge that is sitting with the express authority of an elected judge can actually move forward with those. dealing with section 2-6. Moving on to page 11. This confirms that someone that's a sex offender remains on active probation until court orders otherwise. This prevents DCS from having to file a petition to keep them active on supervised probation. You want to add anything anywhere? Go ahead. Moving on to page 12, and this is all in section 2-6. Here we're dealing with the financial obligations at sentencing. And especially if you look at lines 380 through 388, we are looking at what the court shall consider in determining the financial obligations other than restitution to impose on someone, defendant. And we have A through F that are listed there. And as we were looking at with bail earlier, we're looking at the purpose of a fine. Again, the one size fits all. A $500 fine for some of y'all is like, some people I know is just, writing a check and going home. But for others, that can be a financial hardship that can really put them under. And so we're making sure that that the court shall consider A through F there when they're actually assessing fines, again, other than restitution. Line 408 at the bottom, we confirm that the court may waive, modify, or convert certain fines, like to community service, other than a statutory surcharge, where there is a significant financial hardship or inability to pay. And moving on to page 13 there, we see at the bottom there's a presumption of financial hardship where someone has developmental disability, is totally or permanently disabled, or is indigent. And then section 2-7 is just some cleanup dealing with felony fines. Section 2-8 on page 13. This confirms that DDS can offer limited driving privileges to participants in accountability court programs who meet statutory requirements. Still in DDS on section 2-9 on page 14. This expands the opportunity for judges to order DDS to reinstate driver's licenses and use of limited driving permits and ignition interlock devices. Page 15, section 2-10, we're getting into community service in particular. And first we're doing on page 15, starting on line 510, we're expanding the types of agencies that the courts may approve to participate in community service. As we move on to the next few pages, we're also adding, look on page 16, we're defining, starting on line 526, disabled person assistance, and also on line 530, educational advancement, are two other ways that community service can be utilized, two other things we're adding to the code here that can be used for community service. The next few pages all deal with cleanup language to address that expansion of the agencies and expansion of those two new areas of community service until you get to page 19 under section 2-12. And section 2-12, this is just confirming that there will be a timely hearing when a petition is filed by DCS to terminate probation. That's an unopposed petition. There was no time requirement in the code when the judge would actually rule on that.
Can I ask you a quick question about, so the concept is educational advancement in lieu of a fine. Give us an example of that.
Well, that's not just in lieu of fine. That's actually adding another means of community service.
Okay.
And now, yes, under
So it's equating personal improvement, I assume, with,
Yeah, so just
Yeah.
as you can convert a fine to community service, the judge could convert a fine to educational advancement, could require educational advancement as part of the sentence separately. This is also to say everything in here still requires the judge to approve it. There's nothing in there that gives a defendant the right to using a GED course. It's only with the approval of the judge.
but I mean, there's service to the community and service to self.
Mhm.
So if you're, and I understand that part of criminal justice reform obviously is getting people back on their feet having them be productive members of society. Understood.
Yep.
But I mean, they're not really in that situation if the judge uses that as a substitute for community service. While it's well-meaning and it helps the individual get back to where they could be and should be, it's not really they're not doing anything for the community, they're doing something for themselves. Is that a credible argument or no?
I would suggest that the judge in that instance would probably be imposing community service obligations also as a condition of the sentence.
But they didn't have to. They could just.
No, but they don't currently have to either. So I understand the point that you're positing. I think that the judge, the elected judge in that scenario, is going to be looking at probably some combination of the two. I don't think you're going to have an instance where somebody's going to be able to satisfy all of their financial obligations based off of educational advancement. In theory, a judge could order that, just as a judge could now order community service to satisfy all financial obligations. But I don't think, other than restitution. But I'm not sure that's necessarily the case now either.
Okay, thank you. Mr. Setzler.
To the chairman's point, I wanted to follow up on the education question. I was actually at a symposium on Friday at Kennesaw State that dealt with criminal justice reform. And the idea was brought up by the speaker, is it good public policy to educate people in our prison system? I think most folks would say it is, makes sense and so forth. But, in the context of constrained resources, I just want to ask this question. I mean, we ask a group of 60 college kids, would you give back $500 on your Hope Scholarship to redeploy those dollars to educate people in our prison system? Because in the context of scarce resources, we're spending money. It's not sort of an unlimited amount of other people's money. I mean, so I was sensitive to the chair's question. In the context of scarce resources, I don't know what programs we're talking about. I mean, it's I think in the spirit of criminal justice reform, it seems consistent with some things we've talked about. But given scarce resources, would those dollars be better spent on somebody who's followed the law, who's trying to work their way through college, I don't know if we can put some more meat on these bones, but it is a fair philosophical question. Should we commit scarce resources to?
So I would posit one thing first, is that the defendant we're talking about here is likely unable to afford their statutory fine, and it's being converted for that reason. So I'm not sure that it's necessarily foregoing dollars that would otherwise be accepted by the court. And to also posit that, a lot of what we've done in criminal justice reform is save the state significant financial resources, and that the governor has put an emphasis on while protecting public safety. But another aspect of that is reinvesting into our criminal justice system so that you're tackling, hopefully, recidivism rates.
Yeah, and I'll add to that, again, keep in mind that this is probably someone that if they had plenty of money, they could just pay a fine. But because they don't have the same job other people have, same education, same background, whatever their circumstances are, they are having to go a different route. And so I think there's no better investment we can have in our state for folks to get an education and to give back over time after they are able to get employed. And so this bill, of course, doesn't deal with taking someone in prison and paying for their education, I know. But I would rather invest the dollars in these people who could stop a cycle of crime versus paying to lock them up every single year.
I hear you, and again, a great affection for the senator, and you've been in these very seats. I just, you take two people, one guy decides to rob a convenience store, the other guy decides, nah, I'm not going to do that. The guy that robs a convenience store, after a series of encounters through the criminal justice system, ends up getting his welding school paid for. The schlep who didn't do that doesn't get welding school paid for. He's just as broke as he ever was. But the guy who got into the system through a series of misdemeanor acts is now getting an education paid for. But the guy who didn't, who said, you know what, I'm not going to do this, he's still on the outside looking in thinking, how do I get welding school paid for?
I should also point out that what we're talking about here is not necessarily a state-provided educational advancement. This is something that the individual is going to be seeking on their own, whether there's grant money available through other avenues, possibly, but this isn't a, you know, DCS is not providing the course, so to speak. I don't mean to single out DCS specifically there, but as an agency, for example. And again, the judge is always going to have the ability to say whether they're going to allow this or not. I think it was a fair recognition to say that the defendant shouldn't necessarily have a statutory right to this alternative.
Vice Chair.
Thank you, and I've been in and out during the hearing, so I apologize if this has been covered, but on what we're talking about right now, is this, you know, what I've seen as a practitioner in this, oftentimes, for example, sometimes a judge will, as a prosecutor, I lost count of the number of sentences that I negotiated, and then as a defense attorney for clients as well, where a condition of probation is to get your GED or something to that effect. Sometimes I've seen judges fashion an early termination of probation upon completion of certain conditions, one of which being completing their GED program, something to that effect. Is this just kind of codifying the spirit of that, as opposed to, I may be misunderstanding this, but I'm not reading this as providing state-funded money for these type of self-improvement things, but just as simply as a way of codifying. I mean, I see it happen all the time. Judge Hightower, I'm sure you deal with it all the time, where you figure out ways to work around fines and that someone, whatever their penalty may be, we figure out ways that they can pay that, whether it be through dollars or through some other type of action and conduct on their part that shows good behavior and good intentions to make up for whatever it is that they've done. Is that fair?
That's correct.
Yes.
And if you look at it in the framework of that, you know, each time community service is referenced, we're referencing these other aspects too.
Sure.
So it's trying to bring it within that same framework.
Mr. Bodie, did you have something?
Yeah, just real quick. I'm sorry I didn't catch this earlier. I just want to go back as a point of clarity to where on page 12, where we were talking about the statutory surcharges. I think we start on line 392, or it's on 393. Now, I know as the vice chairman stated, he's a practitioner as well. Statutory surcharges have always been something that judges did not want to touch because there are constitutional statutory surcharges. So are you saying in this particular section that community service will also be allowed in lieu of paying the statutory surcharges? And could we get some language in there which state even with fines, statutory surcharges, that the judge can allow up to maybe 90 to 120 days to start to pay on those? Because I know a lot of judges like to do that, but you know, maybe we can have something in as well, say may, not a shall. But I think that's kind of good because that's kind of in the spirit of what a lot of judges do on a case-by-case basis.
So I think that's sort of where the council had started at, but I do want to point to you on lines 414 through 416, which was added in to get at the point that you're making there with respect to if the court waives a fine under the paragraph, it shall impose a theoretical fine, and the defendant shall be required to pay the statutory surcharges associated therewith. I think there's a broader policy discussion that needs to be had as to what the proper route of funding some surcharge programs is. But until that conversation occurs, it's important that we recognize that this perhaps unintended consequence and allow it to be set aside for the moment. So,
Yeah, because that's a big issue in courts all the time. The judge is like, well.
they're based off an X percentage of the fine and. Sure.
Exactly, because the only thing that the judge can really help a defendant out with is with the fine and not necessarily the surcharges, because it's a constitutional mandate that the surcharges can't be waived.
Sure.
Okay, thank you.
We also just rely on so many of those surcharges to pay for so many different things, and that's, as Mr. Miller was alluding to, is a probably bigger discussion we need to have outside this bill as to what we're funding with those surcharges.
Okay.
It gets you all the way through to page 19.
say 27, so they notice the difference, I think. Okay.
Yeah. You want to move on, Mr. Chairman?
Yes, please.
So now I am through page 19, I believe, and start at page 20, section 2-13. This section is dealing with the way you can retroactively limit public access to your first offender sentencing information. And what we're doing on line 660 and line 661, if you're currently still in the term of a sentence, you can actually go back and retroactively, this was a Senate bill from last year.
174.
174. But we're making that retroactive, so someone that's still underneath the sentence can go back and petition a court to have their first offender